So thank you everyone for joining us. In particular, I want to thank Brett and Craig, Andy when he gets here, for participating in the second session of our ESI protocol series for the Wisconsin Midwest Chapters ACEDS group. I'm Kat Trago. I'm the Wisconsin president of the Wisconsin ACEDS chapter and kind of the ringleader for the Midwest group that we've pulled together here. I'm going to, if you have questions or comments, please put them in the chat or the Q&A. We will be monitoring that. Other than that, I would like to quickly introduce Brett Burney, who is going to be moderating today's panel. And at the end, I also want to let everyone know that session 3, which will be a judges panel moderated by David Horgan, the registration is going up today on that. And I will also drop in the chat a link to our website for, for our series website that gives a lot of information on, for instance, the past recordings. It'll give the materials. When this recording comes up, we'll put that there. So it will serve as a reference for people going forward. So I think I have wasted enough time. We have a reasonable amount of people that have gotten in now. And Brett, I'd love to let you just take it away. Thank you so much.
Thanks. And I do see more people trickling in as well. And Kat, I'll let you can talk with Pam. It sounds like some people needed just the link ID. They were having to search it. And hopefully, Lars, you have hit the recording button so that for the people that were not able to get in, they're going to be able to catch up with all of this. So it is great to have all of you here with us today for part 2, as Kat said, of the 4-part series on evolving ESI protocols. And this is being brought to you by the collective of Midwest ACEDS chapters that includes Chicago, Denver, Detroit, Ohio, and Wisconsin. I know this is a long URL down here at the bottom, but this is a way that you can get to like the overall page, because once you get there, you will be able to, this is where you'll be able to access the recordings and the materials once we get them posted. You can see already that part 1 is available now, so you can go and watch part 1, which was on February 29th, hence the leaping forward theme that we have here. You can download the resources there as well. And so a couple of days after this presentation, you'll see part 2 available there as well. And I think I've got a link in the last slide or 2 here where all of you can get ready and sign up for part 3, which is going to be great. And then part 4 coming up. I think part 3 is going to be in June, and part 4 hopefully around July. That'll be what we've been calling the workshop, so that you can sort of put all of everything together from these sessions and help to understand how to actually create a modern day ESI protocol. Just a quick shout out to our sponsors, the great eDiscovery Assistant tool and platform for looking up eDiscovery case law, BDO, and NextPoint. Which I think we are putting together the availability of folks to get the eDiscovery for the Rest of Us book, which NextPoint just recently relaunched with Tom O'Connor. So I'm pretty excited about that. Either an ebook, or I think at the last session we'll be also making sure that folks get physical copies as well. But today in part 2, we are going to be focusing on modern musings and present day pitfalls for protocols. Really just wanted to go through and highlight some of the considerations that we probably didn't even have to think about just even a few years ago. Not that everything has to be included in these protocols today, but just a few things to make sure that you are not missing, that you're considering. Our panelists today, my name is Brett Burney, and I am working with NextPoint as their e-law evangelist, but our panelist, Andy Keck, he's not here quite yet. He is the Chief Technology Officer for Profile Discovery in Columbus, Ohio. I always enjoy talking with Andy on topics around cybersecurity and mobile device forensics. We're also joined by Ann Costello, who just joined Epic a few years ago as the Senior Information Governance Consultant. And we invited Ann to come and join us today to talk specifically on that information governance side around the world of Microsoft 365 / Office 365. And of course, most of you probably do not need an introduction to Craig Ball, who hails from Texas, as well as New Orleans. I, just like many of you, have followed Craig for years in all of the educational components.
Despite the restraining order.
I know, and that's good. But we have just always felt indebted, I know, as I speak with a lot of my colleagues, to Craig for the fact that he has provided so much over the years. And now that I know Craig, I know one of the things he's most proud of is the fact that he does teach electronic evidence and digital discovery at the University of Texas School of Law. And as many of you that have been following Craig for a while probably know that Craig's had a few thoughts, right, over the last few months, couple of years on ESI protocols. And so we asked Craig to start us off today to kind of set the stage, as it were, with some of his thoughts around ESI protocols and just kind of helping us start the conversation, as it were, about some of the things that may or may not need to be different in today's world of protocols. That's you, Craig. Now that you're in like the mountains behind you. He
Yes,
was in
I'm
federal
coming
court
to you-
before, and then
coming to
now
you
he's
for
like in
my-
the mountains.
my mid-century Bond lair here, Bond villain lair.
I love
Mr.
it.
Bond, we want you to die. So, with that in mind, would you be kind to? You're in charge of the slides,
Yes.
Mr. Blofeld. So
Look
would
at that young guy. Wow.
Holy cow.
I'm the one. Oh, say you. Oh, there you are. Thank you. This story goes back to 1982, a mere 42 years ago. Next slide, please. That is me, in fact, being sworn in as a lawyer 42 years ago. Next click, please. And back then, I went and joined my new law firm as a very green associate. And I went to my office, and there, abandoned by its prior owner in my office, was a set of books called Miller's Standard Insurance Policies Annotated. Now, as a fledgling personal injury trial lawyer on the plaintiff's side, I will tell you the secret of my modest success. And that is where we are taught in law school that there are three legs to the stool that serves to support a case. In the case of personal injury, negligence, causation, and damages, any lawyer worth his or her or their salt can tell you that there is a fourth essential leg of support, and that is coverage, getting paid. And in this wonderful set of books that proved to be a gold mine for me in terms of how to plead my cases in order to implicate coverages and not make some rather boneheaded mistake that would cost my clients the ability to be paid if we succeeded in proving their case, was this book. And it would have the clause of a policy, an auto policy, homeowners policy, casualty policy, and then it would have a column to the right explaining the interpretation of the law, the applicable cases, and so forth. And I felt I owed a debt. And so early last year, next slide, please, as I sought in my small way to repay that debt, I went through and I identified all of the variations of ESI protocols that I could find, those in reported cases, those solicited from my esteemed colleagues, those I had written and promoted over the years, and sought to harmonize them so that the language and the approaches were sort of structurally consistent. And then I put those things into the format that I borrowed of the annotated protocol with, next slide, please, with the clause on the left, and then my explanation of what it means and why it's important and what the variations might be on the right. And as a consequence of that, I had to provide one other bit of catnip, as it were. Next slide, please. And so, although I hate the form practice of law and I abhor the notion of taking some form you grab off the net, changing the names, putting it out there and creating a lot of headaches for everyone because you really haven't fit the protocol to the needs of the case. But I do appreciate that if I want people to pay attention, I have to give them something. Next slide, please. And that something was an exemplar protocol, 7 pages of something that you can pull and plug and adapt. And the operative word here for me being adapt to the particularities of your case. Next slide, please. So we should lay a little foundation. I'm sorry, one more, please. A little more foundation of what these things are. In the article, I define ESI protocols as something that sets out the routine obligations of the parties respecting such issues as preservation, identification, and importantly, forms of production. For the most part, it manifests as an agreement between the parties, negotiated, put into writing, and signed off, but increasingly, occasionally imposed as a court order. And these protocols, when they get ambitious, may also address search strategies, technology-assisted review, validation, confidentiality, and so forth. Next slide, please. As I approach these for folks, I try to say, keep it simple. Stick to what I call the core provisions. And those things, to my way of thinking, are the election between a native forward, TIFF plus forward, or some type of hybrid production formats incorporating some measure of both. They should set out the metadata fields, and that would be such things as the application metadata that is inside the files and is extracted, the system metadata associated with the evidence when and where it is collected, and the assigned metadata fields, things like hash values and Bates numbers, those things that will comprise ultimately the load files produced along with any production nowadays. It should set parameters for integrating old forms of evidence, such as paper documents, and whether those should be supported by searchable text, and if so, text extraction, OCR, the resolution, DPI, etc., for those paper documents, because we still run into a fair amount of paper, and it's important to be able to integrate it in a utile way in our production. So that's a very standard form, often not at all contentious form, but we have to consider such things as color. How will we support color? What forms will it take? Is a static image going to be a PDF and load file, a TIFF plus with load file, etc.? We need to address whether deduplication will be supported in what way, logical unitization being the ESI counterpart to the more familiar physical unitization we take for granted, things like paper clips and staples and folders and drawers, etc. How do we manifest those in an ESI world? Whether or not threading of conversations in email and messaging is supported, and how, and perhaps even pinning down some of the privilege logging process. Next slide, please. And so for me, this process of starting out with an ESI protocol is crucial. First, it serves by keeping it simple, by finding areas where you can reach early consensus. It allows you to kickstart the process. No, you can't fix everything. And if your ESI negotiation process is going to require dozens of meet and confers and endlessly costly wasted time of quibbling, then I think you're going in the wrong direction. So this protocol is a way to early on demonstrate a path to consensus, show that even though you are opponents dedicated to zealous advocacy for your clients, you can come together as professionals and find some areas of common ground, because in every case, there are going to be some things you have available that are going to need to be produced. And if you can establish the essential elements of an ESI production protocol, you can get those things exchanged early, begin determining what is the language used, what are the forms used, who are the key players, and you can begin honing and refining your discovery efforts so as to be less wasteful and more proportional to the needs of the case and the issues in the case. And I think just the process of negotiating a protocol gives you crucial insight into yourself, your own clients, and your opponents. Immediately, as you start to discuss these issues, you're going to find out, and you will demonstrate with regard to your own abilities, whether your opponent understands issues of eDiscovery, whether they are dedicated toward a scorched earth, give nothing approach. That is to say, they have no sense of what is required of a professional in the give and take in electronic discovery, what it is that judges today insist upon in advocates being able to a certain extent set aside the tactics of discovery and work together with a modicum of good faith. And it forces you to consider what your clients have and to ensure that you've put proper preservation protocols in place, and whether or not you can provide in the sauce for the goose, sauce for the gander realm, you can provide the same things you ask for. And so let's wrap my part of this up with the next two slides, please, Brett. And, I say in my article that these things are not about deciding what's going to be produced. They're not about the scope of production. They are about establishing the kind of geeky details that vendors need to know how to set up their production, to be able to move forward, take the next steps, ensuring that what is exchanged is not only the right stuff, but that it is provided in forms that are economical and complete and utile. Next click, please. Not boiling the ocean, as it were. Next click, please. So again, don't set the scope of discovery. That's for your request for production. If you're fighting over what you're going to get, not the form or the medium, then you've missed the point. Next and final slide for me, please, Brett. So again, don't try to do everything in an omnibus protocol. Find where you can get a reasonable meeting of the minds on the things that are essential and what I call those core provisions. And perhaps you want to defer search term discussions that can be rather contentious and expensive. You might want to defer briefly TAR validation. You have to come back to those things, certainly, but you'll find that it's an easier return trip to work out the harder issues if you've shown that you can trust one another and you can find common ground on the less contentious things. Thank you, Brett, for advancing the slides.
Excellent. Of course. Thanks, Craig. Can I just ask quickly, and Ann, you can jump in as well on this. In these core principles, I'm just going to jump back to your slide here, Craig, because I think this is good to just like how far beyond would either of you normally counsel folks that you're working with to go beyond this? I mean, would these core provisions, Craig, be like the initial draft of it and then you can modify later on down the road? Or how far beyond these core provisions would you even start with, if some of that makes sense?
I don't want to jump in ahead of Ann. I think you asked the question Ann first, but quickly, if I may, it's not about a framework that sits around unexecuted. It's about finding something you can put your names to, that if you need to, you can submit as an agreed order for the court, something that gets you moving forward. So those things you have at hand can be exchanged without costly do-overs, Brett.
Yeah, good point. Ann, did you have anything you wanted to add
Well,
there
and
kind of thinking about these?
I'm going to echo what Craig said, and what we're definitely seeing is we're going into the protocols, making the definitions. And as we start actually getting into doing collections, we're finding that customers that are custodians are using data in ways that we never expected.
Yeah.
And the business isn't aware of this. The attorneys aren't aware of this. So we have to go back continually, that this is a starting point. I'm not an attorney, but as Craig said, we have to have something that we can put in front of the court to show that we're working together. But we have to expect that we're going to start going through and finding new data sets, new ways that our custodians are working with technology that we never expected and expect to adapt to that. So Craig had used the word adapt multiple times.
Yeah.
Using the word evolve, expect that this is going to be evolving throughout the life of a case and discovery.
That is so important because, at least in my experience, many times if I'm working with a litigation team, they think that the protocol is sort of, this is the agreement. We have it signed and then it's done. And then it's sort of set in stone, Craig. And I try to tell them, like, we got to start somewhere, and we can modify, we can tweak as we go through, because, and to your point, we always are going to find something that was unexpected, something that was a little out of the ordinary. Then we are going to have to go back and retweak. So I'm glad that you're at least presenting it this way. It's just, in my experience, it feels like a lot of people don't think of protocols in this way, and that's unfortunate.
Yeah, and especially since, and we're going to go in and start talking about Microsoft 365, part of our discovery, we're doing interviews with our custodians, figuring out where they were saving data, what it was. But so much of our software today is designed to make life easy for them that they don't necessarily know. I was looking at it here in a PowerPoint file. They don't actually know that there's a back end SAP or Salesforce feeding in what they're looking at. We discover that throughout the process, and it's a conversation that's ongoing about how are we going to present this data.
Well, that's an excellent segue that you just made there, Anne. How about we jump right into that,
Okay.
and just in the sense of what are the things that you are seeing that, as you're consulting with your clients and the folks that you're working with, that these are some of the things maybe initially right off the bat that you need to be considering, that maybe not all of it's going to show up necessarily inside a protocol, but it's certainly some of the considerations. What are some of the bullet points that you're making sure that you're covering with folks when you're working with them?
Sure, and I don't have any fancy slides with animation the way Craig did.
That's okay. I'll wave things around for you, move things around while you talk. So,
so much, and I'm working almost exclusively in the Microsoft 365 world today. And the very first thing that both our legal departments and our law firms should be considering is what type of Microsoft 365 licensing a customer has, and specifically what licensing our custodians have, because that's going to dictate what tools are available to you to collect that data, and in the format that it will be exported in, and what you can do with the data. So Microsoft has 3 tools built into their Microsoft 365 platform that can be used to collect and search data. And one called Content Search, the other called Standard eDiscovery. These are covered with the lower licenses of Microsoft. I'm not going to get into the details of Microsoft licensing today because you could get a master's degree in that. And I do not have that. And then there's the premium eDiscovery, which requires additional licensing. The tricky thing is Microsoft, as they develop additional cool products like Teams, like Copilot, like Microsoft Loop, the tools that they are providing to do the collection of that data are all going into the premium eDiscovery tool. So one of the first things you need to do, you might have worked on an eDiscovery case with one customer who had Microsoft 365. You can't make the assumption that they both have the same licensing. So you have to figure out what licensing they have. And work with both your vendor or your in-house litigation support group to talk about the export formats that come out of that, of what product we're able to use and how you're going to incorporate it into discovery. And you want to be aware of that before you ever talk about a protocol, with the other side because you need to know what you can and cannot do. And then you have to understand how the client is using the Microsoft tools itself. We have seen that, one of the key cornerstones in Microsoft today is Microsoft Teams. And most corporations do not use Teams in the same way that law firms use Teams. And most internal legal departments do not use Teams in the same way that most of their knowledge workers within the company do. I find myself doing a lot of education with legal departments where I go in to show them the tools, but first the eDiscovery tools, but first I actually have to give them a tutorial into Teams to show them how it works and give them understanding what their customers are doing. If we are collecting Teams conversations, they might live in multiple places. They might live in a user's mailbox. They might live in a mailbox dedicated to the team. They might live in a shadow mailbox dedicated to a team. This data could be all over the place, and we have to understand how people are using that. And then, and Craig, the next point I'm going to talk about as far as the technology, Craig has written a couple of really good articles about this recently, is we also have to understand and consider how people within the organization are sharing files. Traditionally, we're used to email, hey, go get Joe's mailbox. All the email attachments he ever sent are in that mailbox. It's a nice discrete package that we can deal with. That's not how it works anymore. Microsoft has introduced something called cloud or modern attachments. These have been around for a long time that allow us to link to a file rather than sharing a copy of it. And I personally love this because it allows me to work on reports with my coworkers. We're all in the report at the same time doing our edits. When I first introduced an attorney to that, he's like, why would I want to do that? I don't want anyone else in my documents seeing what I'm doing. Again, I'm not an attorney. I love this. But the problem is, from an eDiscovery perspective, is I collect that email, the attachment is no longer there. It's saved on a SharePoint site or a OneDrive site. And it might be saved on the OneDrive of someone who's not even a custodian in your case. And you have to consider whether or not you're going to be collecting that, how you're going to be reviewing it, how you're going to retain those relationships. And again, this is something to talk about with your vendor and your team. The eDiscovery Premium tool will give you ways to preserve those relationships. Microsoft is improving what they show us, but they'll give us ways to see those relationships that your vendor can massage and get into a review tool for you to be able to look at. But you need to consider all this and whether or not these matter. Any attachment that is sent in a Teams message is a modern attachment. Microsoft, with the Outlook tool nowadays to conserve the space of people's mailboxes, is constantly recommending to your end users that they send things as a cloud attachment. So you need to be aware that you're going to see a lot more of this.
I'm going to stop you there. Let's address that then and bring that around to the protocol. Yeah. And I want to hear from you, and then Craig, maybe you can jump in with your thoughts as well. Is that something specifically then that we need to make sure that we are including in a protocol today? Do we need to have some kind of a language, and what are you seeing, or Craig, what have you seen or advise folks that they should be including from that perspective for specifically cloud stored attachments?
I'll give you what I'm seeing, and then Craig could give you much more of a legal answer. But because in the past, a lot of the advice has been, we don't need to produce things that are hyperlinked. I hyperlinked to a Google site. I don't need to produce Google. And I have met lawyers who said, we don't need to produce that because it's a hyperlink. And at the beginning of times when it was a brand new thing that I shared a link to a document on a Google Drive or something that was difficult to collect, I can see that. But nowadays, in really just in the past few months, I am seeing at customers that well over 50% of their email attachments are cloud attachments. So along with what it may or may not be your legal obligation to produce, just based on the lawyers that I grew up with, I can't imagine why you wouldn't want to collect that, because you are developing the facts of your case. How do you know what the facts of your case are if you're not reviewing this data? And Craig has lots of views on this.
Share some with us, Craig, please.
Well, actually,
Yes.
well, why don't we I'll be happy to, but why don't we let Andrew come on in? He's, I think he's waiting, and he's certainly an expert on Purview.
Well, yeah, experts a stretch, and it's funny because they and sorry I'm late, everyone. Technical issues, get some protocol for that, but we ran a test to bring up modern attachments, and what we did was we went in, we exported an email with a modern attachment, and then we went in and modified the attachment in OneDrive, and then we went back to that. Then we re-exported that same email out that had been sent 2-3 years earlier, and then linking to the new modified document. So that, just to throw a wrench in that protocol as well. So
that's an interesting thing. I'm sorry, Andrew, you were breaking up and I spoke over you. Do you
that's
have,
all right. No, that's it. Go ahead.
what's interesting to me about that, and this is a big deal, and what Andrew's talking about is a link to a modern attachment is a live link. So again, I make a change to the report, my coworker makes a change to the report, I follow the link, I could see my coworker's changes. Microsoft does preserve versions of each one of these. So in theory, you can go collect the version. But the tools today from Microsoft are always going to collect the latest version. Microsoft has introduced ways that we can mark what version was shared. So we can implement that for our cloud attachments going forward, but it's not good. Most of our litigations right now are about things that happened 2 or 3 years ago, right? So that's not going to help you today. And in addition, getting that set up usually involves someone that is not part of the eDiscovery group. So it is a systematic change that you need to do to Purview. That being said, so there are third-party tools that will go and collect the version that was shared. But it is part of what needs to be established in the protocol. It doesn't matter if it's the latest version, which is what you're going to get natively with Microsoft, or if it's or you need to collect the version that was shared. I'm going to give, before Craig, I want to give, this is not a new thing. One of my first SharePoint collections, an attorney comes to me and says, I have an email that has a screenshot in it of what this document said, but then when I go to the version of the document that we collected, it's completely different. And it wasn't a document, it was a wiki. And they had put a screenshot of the wiki, and I had to explain to the attorney what a wiki was and how it is a continually evolving document. And he was like, well, why the heck would they do that? Well, they were not considering eDiscovery when they started working together.
Right.
And we have always had evolving documents. But now it is one of our primary sources now we need to think about. And Craig.
Can I jump in? I do want to make sure Andrew has a chance to talk about his topics, but let's scroll back for a minute before we start dealing with what I regard specious arguments like I shouldn't have to collect anything that's hyperlinked. First of all, we've had hyperlinks in emails forever. I mean, how many listeners, if they look at one of their email signature blanks, has a hyperlink to their firm or their email address or something along those lines? And we've never felt like, because of hyperlink was in there, by virtue of being a link to a public site, that meant we had to follow down that rabbit hole. So let's put that's a distraction. These are attachments. We call them that for a reason, even though they aren't embedments in the email any longer. They are the intent to transfer a document from one participant in the conversation to another. And you know what that makes them sometimes? Evidence. And if we care about this justice system, if we care that decisions are made on competent evidence, then just as Anne said so well, we need to be sure we collect and process that evidence. Thank you, Microsoft, for taking Purview E5 to the next level and allowing it to be a one-click, now albeit not free, nothing is free, but before we talk about that, why did everyone move here? Did they move there because they just wanted to claim they were in the cloud? No. People moved into the cloud because it saved them money. It gave them additional, advantages. And there's a trade-off to that. It means that we have to adapt our eDiscovery. So some of the savings we got by virtualizing our once behind the firewall environments now are going to be lost to the fact that we have to do discovery in the cloud. Sorry, folks, but we follow the evidence in this business. That's what lawyers do. That's what service providers help us do. So there is a way to do this. And yes, some documents are interactive, are evolving, as Anne has described. Some are collaborative. In my experience, most are not. Most are just a way to transfer something and nobody goes back in and changes it again. But whether I'm right and it's most, or I'm wrong and it's less than half, we can find that out and we can deal with it. And we can just determine that if we're getting attachments collected and they are not, they've lost their relevance, or they have some authenticity or admissibility issues, we deal with that as questions of admissibility down the line. That's what judges are really, really well trained for, and they've done well for centuries. It doesn't impact the obligation to preserve and collect and assess. It's discoverable, even if it may not be admissible. And once we get that into our we're lawyers and we don't want to change heads, we will get to the point of realizing we must deal with the attachments because that's where the evidence lives. I'm stepping off my soapbox, inviting other points of view.
It's a good box. It's a good soap and good box. I like it, Craig. So Ed, based on that, quickly, I would just hope, because I've heard Craig said this before, and I believe it. It doesn't change your obligation to preserve. And I know, of course, Microsoft 365 has some components of preserve in place. Is there any kind of specific, maybe items that should be addressed in the protocol from that aspect? Like, you need to keep Teams data in a PST file format or something like that. Should we try to address some of that in the protocol, or maybe, like Craig saying, that maybe comes up as an admissibility question? Have you seen any of that or had to deal with any of that?
Oh, honestly, I have not seen a whole protocol regarding preservation for a while.
Okay.
But from the technical standpoint, Microsoft, when you can preserve the data in place, so you don't need to go collect it. You could be preserving it in place, which is excellent because it means that you can go back to the well. You don't have to go and collect a bunch of PSTs to preserve the data and hold on to. Microsoft's going to take care of it for you so you can go back to the well and find it after the fact. The thing that parties need to think about is, one, yes, you go to preserve and you preserve the most obvious. You know that you have an obligation to preserve. Let's go in and get their mailboxes and their OneDrives preserved right away. And a lot of companies had not been preserving OneDrives because they have been using traditional ways of doing this. Premium eDiscovery makes it very easy to do this. And then you're going to have to identify beyond that where the customer has been the custodian has been working, and go back and do preservation on these items. Counsel should be coming in and asking right away for what the customer's retention schedule is. Understand that we're holding on to Teams data for 6 months. Great. Now we have a little bit of time period to start figuring out what we need to put on hold before this stuff starts disappearing. But you should know that you need to go back and place Teams on hold. You might have to place their coworkers' OneDrive's on hold, even though they're not related to the case because they have data. So you have to think of preservation as an ongoing process. As you discover data, you're going to have to be going back and perhaps doing preservation or lifting preservation.
May I add something, Brett?
Yeah.
To your question about the role of the protocol here. My view is that at least now at this stage of the game, it's wise to have an explicit reference to how you will handle cloud attachments, so that there isn't any misunderstanding, that there's an expectation that if there is going to be the use of a vendor environment for processing and search, that cloud attachments will be collected. You may even want to put in a provision for dealing with the resolution of versioning. If there's an indication that a version may not be identical to the transmitted version at the time of transmittal, then either you have a meet and confer process prescribed, or you may say, as I've done in some, that you'll provide the copy closest in time to transmittal. And to the extent there's a question about whether it's still relevant or there's some kind of prejudice that arises from providing this thing that may not be 100% faithful, that the parties get a chance to air it. And that's what I say. So don't lay behind the log. If there's something you're worried about, put it in and make some provision for at least a later meeting and conferring, so that people don't show up in court later on and they go, gee, Judge, it never occurred to us that 25% of the things our people transmit never got picked up. And now they're wondering why we're not producing those things.
And it's quite possible we're missing just as much with keyword searching. A few years back, I got to do some nerd simulation. It's not quite like a flight simulator flying an F-15. It's more in our eDiscovery industry. Is we got to try to run some keyword searches, and what it was a database that was already reviewed for responsiveness. And you might have done an exercise like this as well. So you could sit there with your team and you could run as many keyword searches as you want. And time and time again, maybe the best results were coming back at 65%, 70%. And so I think about, hey, if we're doing these protocols to run keyword searches over purview, well, that's what we do. That's what law firms have been doing. That's we moved from paper, now we're into keyword searching. So when we look ahead as what is a potential pitfall for me, I say, well, now in that, if we're going to miss that much data from what we're pulling out of Microsoft, then that tells us that we have to kick as much out of Microsoft or Google or any other platform. And then we use different AI models and different tools that will now only not just put in the keyword searches. It's going to, which Microsoft doesn't have, by the way. It doesn't have things like brain space, where as I put in those keywords, it's going to suggest 10 other words. If I put in the word tree, it's going to start mentioning branch and leaf and acorn. Of course, I like acorns, like the next person. And, then we go in and we run an AI model over junk or different things that, what did they say? And I think Andrew Peck said that in TAR 1, they equated to be as accurate as human review. So unless you're going to review every single document, and now with like TAR 2.0 and continuous automated learning, we're getting into those calibers of high 90s percentages of finding relevant data. So if we know that keyword searches alone are not pulling back relevant data, then how do you see that factoring into protocol when different firms and different clients have different systems? Can that be addressed later on, or do we have to, because as we're going through and making these decisions based on protocol that we've received, we're making these decisions sometimes with no real guidance, and we're saying, okay, well, hey, if I dedupe inside of Microsoft 365, there's consequences. If I don't dedupe, then there's more data. Things like that. What are your thoughts on that?
Yeah.
Oh, please go ahead.
You done?
Oh,
Okay.
for sure. Um,
I'm gonna say, go Craig, and
no,
then
no,
I'm gonna
please,
say
please,
it.
ladies first, if you'll pardon an old misogynistic phrase.
Thank you. I get a little overexcited about this. First, part of some of the things you're talking about, Andrew, are very true. Microsoft, for example, doesn't have a good AI TAR tool at the moment, though something we have to think about and is you need to think about the fact that Microsoft is continually evolving. So things like, and you always have to think about what tool is being used. So we've been talking about premium over standard. The keyword search tools in premium, because it does deeper indexing in OCR, is far better than what we have in standard eDiscovery. If I'm working with a customer who does not have the premium tool, yes, we're going to do broader collections and put it in a system where we could do better searches. The thing that I want to make sure that everyone understands is Microsoft is changing their products both from the end user side and the eDiscovery side continuously, frustratingly so, in that I will go into a program, into the eDiscovery platform, working with a customer in the morning. And in the afternoon, I'll come in and there will be a new feature that I knew was coming, but I didn't think it was going to be there for another 3 weeks.
Surprise.
Yeah, surprise. And so just because you might consider in a case today, Microsoft doesn't have the tools for us, or Google doesn't have the tools for us today. That doesn't mean that the next case that you're working on 2 months from now, that the tools aren't there. Craig, I know you have thoughts too.
Well, thank you, Ann. And I think you and Andy have both made really important points. I wish I could sit down all the lawyers who do discovery and give them a quick course in understanding that if it's not in the index, it's not going to be searched. And that everything we do in eDiscovery is about the creation of an existing index. If you in situ store, preserve your data in place in Microsoft, and your plan is to search it in Microsoft World, then you are limited to some extent by the quality of the Microsoft index of your documents, the quality and capabilities of Microsoft's intrinsic keyword search. Has it indexed this kind of file? Has it not? Has it indexed 100% of the file? Or does it stop, 100 pages in, et cetera? You have to know the limitations of your tools. Many of the vendors have kind of a tension there. They would prefer, naturally, that you export everything out of an environment like Microsoft, pay to host it in their environments by the gigabyte or whatever, and then let them work their magic and massage the data so it can be searched in their tools. And there are advantages and cost implications to both. But it is essential that lawyers and lit support people understand what's at work there in these two tensioned environments, and where you can gain the benefits and the economies of doing some of that, as Andrew mentions, maybe deduplicating within a Microsoft environment, and then whether you then save money by handing off that now constrained and compacted of some sort selection of data that isn't what it used to be, but maybe it's defensible that you'd save money doing it in Microsoft and then gave less to the vendor. But you have to know what's going on there. And that's what Ann is saying. You have to understand the trade-offs here. We lost Andrew.
I know. Again, I was just getting ready to give
Andrew,
you the last word on 365, Craig, because I wanted to at least hit a little bit of mobile devices. I mean, clearly, we could go for about 2.5 hours, I think, just on 365,
And
maybe 5 times a week. I know.
Product-oriented education, practical education, because let's face
Absolutely.
it, 75% or more of the data we're dealing with now is likely to be hosted in an O365 environment. If we don't learn how to use that, that's like not being able to understand how to use Westlaw or Lexis for a lawyer. You're just not competent.
Great point. All right, Andy, good timing. You're back because for like just the last couple of minutes here, I'm moving us on past 365, even though my goodness, yes, there's so much there that we need to continue to talk about, but keep writing, Craig, and you keep working too on some of this. But Andy, how about just maybe some high level bullet points that you can share with us on what maybe you have seen with mobile devices, things that we need to be considering or including inside a protocol today, maybe from how the text messages, even if we just even stop there, how do we collect that and produce that, or how do we agree for production formats when it comes to even just text messages? Or maybe you can get into a little bit more on some other data from mobile devices, but how about just text messages there? What are some of the things that we're wrestling with these days?
I think the biggest issue is still BYOD, bringing your own device. Working on, I think the last 100 phones we collected, 90% of them were, these intertwined phones with corporate data. And, hey, here's an employee left the firm, left the sales rep, doctor, whatever, they're leaving their places of employment, and they have not only client, we'll launch an investigation if they took a client list, but a lot of them actually have every single client, especially a sales rep, they already have them stored in their contacts. So now we're in this battle over whether or not they're leaving with that proprietary data, and then going into the hey, now we're going to spend all this money to identify which contacts they shouldn't have in their phone because of their employees, or in some instances patients, and then we go in and we have to try to clean that up. Well, as you know, on your phone or my phone or whatever, you have 4 different levels. I have a Google contacts, I have my Samsung contacts, and I have my Outlook contacts, and and then to throw another wrench in the system, the stuff's being backed up. So even if we go and we purge all this data from a phone, from a system, and then even on the iCloud, there's still this iCloud backup that if someone goes and gets a new phone, it's just going to install that on there. So I don't know what the right protocol is to that. Beyond, I can't see us going in and getting to the point where we're able to delete every someone's backup just because it's intertwined with some of that data. As far as production formats, I mean, there's several standards, and it depends on what tool you're really looking at. We can export things out as HTMLs and PDFs if they're small enough, and relatively short message files, and so that type of protocol, I guess with everything, it almost seems like every software out there will do about 95% of what you want. And we're using multiple tools to get through to a production sometimes. And so it would be really helpful, I think, if, you had more understanding of what systems people were using, if they could agree to a certain system, to really identify which system is going to, kind of be curtailed to the best or most the easiest way to review that data and then produce it. So like, hey, HTML is common. Here's a 6-month long HTML version of a chat file with hyperlinks in it. Very challenging to deal with that, versus a relatively short message file that you can export it out of Celebrite with 24-hour increments, or 6-month increments, and things like that. So you won't find that in most protocol. By the time it comes to us to go grab a phone, it's usually, and by the way, quit telling your clients that it's only going to take an hour to forensically image a phone. Please stop that. It's going to take at least 3 hours minimum. And so
yeah, that's great.
I
Thanks,
agree
Andy.
with.
Yeah, go ahead,
Sorry.
Craig. Go ahead.
No, please. I know you want to move it along, and we are running short of time, but I want to emphasize what Andrew is saying, and add, we can put some things in the protocols about these. At least make clear the expectation that the scope will require us to have a form for exchange of messaging data, whether that's a specification of the relatively a single message format, because we're going to be using a review platform, Or for a somewhat less sophisticated user, you might actually want it to be in a PDF searchable bubbled representation. I mean, heaven forbid, but you may want a delimited Excel style CSV format where you can pull it into a spreadsheet. And while it is not, it's unwieldy, at least you can see the back and forth, and you can search it with simple text searches. You have to think of these things, and I recommend you put some language addressing it in your protocol. So again, once the data becomes available, you have a mechanism for exchange of that data. I would also add, and we obviously, and I'm a forensic examiner as well as an attorney. Andrew is skilled in that field. We have the higher end approaches to these things, like Celebrite, for example, and other tools. But there are also lower end tools. And Andrew made reference to perfect, the 95%. We can deal with 95%. It's the 5% that gives us fits, to paraphrase what he said. Well, Voltaire famously said that perfect is the enemy of the good. Well, I think perfect is in a sense the hiding place of the last hiding place of the scoundrel. In that the argument that we can't do it for 100% means we won't do it for anything. We have tools. Some of them are $50 programs. I don't want to pump anyone here, but there are simple programs out there. I'll say one I use a lot. One called iMazing for iPhones. Is it a perfect forensics tool? No, of course not. But does it work for 95% of the things we would exchange? SMS, MMS, iMessaging, WhatsApp, call records, files. Yeah, it works better than nothing by far, and it's affordable.
Right.
So it's not the only one. There are many. It's our job to make provision for phones, because today mobile is the single most important container of relevant evidence. It has long ago eclipsed email. If we don't deal with phones, we're not dealing with the evidence.
Yeah, very good. Any last comments on that quickly, Andy? And then we'll close us out.
Yeah, years ago when email was first rolling in, as far as discovery is concerned, you deal with it however you could. And then as technology got better, you'd expect things like email threading and deduping and things like that. So we're still now just seeing some new technologies come on where it's like, hey, I can go collect 8 phones, and then can we dedupe chat messages across those conversations? Can the softwares reassemble a conversation that took place maybe even between multiple apps? So I would say let's keep our eyes to the future on those types of cool updates as well.
We had planned to have everybody maybe share a takeaway, but I got to tell you, one theme I think I'm hearing all over is you just have to be able to start considering this, whether it's the mobile devices, like you said, Craig, you need to be thinking about this early on, or Ann, where you're talking about Office 365, what subscription level are you on? I completely recognize and understand that so many folks have regular day jobs and that they don't think about these things maybe as much as all of us do. On some of this, but you have to. I mean, this is the world in which you practice, right? So I don't know if you'll forgive me. That to me is the biggest takeaway here, is just being aware. And of course, all the people here are the choir, right? I mean, we're the ones here that are trying to look into the information. And I just want to thank you, Craig and Andy and Ann, for being here. Kat, I'll turn this back over to you because I know we're a couple of minutes over, but I'll put up this last little slide so folks to get more information, get access to the recording of this session after a couple of days once we get it up, and then sign up for session 3, which I think is going to happen on June 6th. Is that right, Kat?
That is correct. So thank you. First of all, thank you everyone who patiently muddled through the technology challenges of today. So ironic. I always feel like it's so ironic that we have, that we talk about all this great technology, and Zoom is often our default, the problem of the day. But thank you very much, Brett. Excellent job as always. And Craig, Andy, and thank you so much for just really a great conversation today. And for everyone else that's still on the call, please join us again for our next session is a judges panel that will be hosted or moderated by David Horrigan of Relativity. And we have judges Allison Goddard and Judge Joel Richland, who will be joining us to discuss how ESI protocols impact them in the courtrooms, things they're seeing, things that they're starting to see, and challenges that, perhaps we could avoid, but also, how it impacts them on a daily basis. So we're looking forward to that. And I also want to just touch on something Brett mentioned earlier, that everyone who attends any of our sessions will be getting a copy, a PDF copy of Tom O'Connor's eDiscovery for the Rest of Us book. It's great. It's kind of a workbook. So I wanted to let you know that if you've registered for and attended any of our sessions, you're going to get that in PDF. But our final session is going to be a workshop of putting it all together, led by Kelly Twigger. And anyone who attends that will get a physical copy of that. And that's sponsored by NextPoint, and the shipping and BDO is going to handle the shipping. So I just wanted to make sure to encourage everyone to continue joining us for these sessions. And the registration for the judges panel is live currently and will be on the website shortly. So thank you very much. Have a great day, everyone. Thank you.
Likewise.